Commission of the Village of Lake Zurich for Wednesday, June 18th, 2025 at 7 p.m. So, Colleen, please call the roll.
Commissioner Castillo.
Here.
Commissioner Giannini is absent and excused. Commissioner Gloaz.
Present.
Commissioner Kovacevic.
Here.
Commissioner Morrison.
Here.
Commissioner Muir is absent. Commissioner Schultz.
Here.
Chairman Stratman.
Here. Let the record reflect we have a quorum for this evening's meeting. And so the first time our agenda will be the approval of minutes from PCC meeting of May 21st, 2025. Commissioners, are there any changes or revisions that need to be made?
Nope.
Okay, hearing none. I would then entertain a motion to approve the May 21st, 2025 PCC minutes as presented.
So moved.
Second.
Call the roll, please, again, Colleen.
Commissioner Castillo.
Aye.
Commissioner Gloaz.
Aye.
Commissioner Kovacevic.
Aye.
Commissioner Morrison.
Abstain.
Commissioner Schultz.
Aye.
Chairman Stratman.
Aye. Let the record reflect that the minutes have been approved as submitted. Then we move to our next item on the agenda, which will be the public hearing. And so I would entertain a motion to open the public hearing for the following application. Application PZC 2025-08 for miscellaneous amendments to the text of the Lake Zurich Municipal Code.
So moved.
Thanks, Hildy.
Second.
Thanks, Sean. Call the roll, please, Colleen.
Commissioner Castillo.
Aye.
Commissioner Gloaz.
Aye.
Commissioner Kovacevic.
Aye.
Commissioner Morrison.
Aye.
Commissioner Schultz.
Aye.
Chairman Stratman.
Aye. So there's no one in the audience, so I don't have to swear them in, and we don't need to swear you in. So,
Yep, no swearing necessary today.
no swearing necessary. So then introduce yourself.
Thank you, Mr. Chairman. Good evening. For the first item, and the only item that we have this evening are the miscellaneous text amendments that we were looking at. We have two tonight to present to you. The first one is to request amendments to the text of the zoning code to ensure that municipal structures, buildings, and other municipally owned land that are essential to the provision of a valid public purpose for the community are classified within the land use lists of all our districts as uses that don't require any special zoning relief or process to be approved. The reason being that every municipal operation, service, building, or structure that has any work or any change to it goes to the village board first and gets its approval. And so it would be redundant to have to go back through any further zoning process if it was already approved by the village board, who would otherwise approve that zoning process anyway. And so as a result of that, all of these types of uses would be exempt from any further zoning review. That was the first.
So should we just interrupt?
Yep.
I forgot to ask, can you confirm the proper notice was given of this item?
Yes, Mr. Chairman. We did publish a notice in the local newspapers no less than 15 days prior to this hearing.
All right, thank you.
Thank you. The second amendment is an amendment to our land development code, simply adding a provision to limit the duration of construction of improvements by means of defining a 2-year site and subdivision improvement period. This discussion actually came up during the review of the Meadowwood East project, where it was suggested that we limit the time that the developer has to complete a project. Had we done this sooner, there are certain current developers that would also have been held to that standard, beyond which then we would take certain appropriate measures to ensure that the developer either compensates the village or carries out the work in a manner that is acceptable to the village. So the 2-year period wasn't present in our codes. If we were to do that in the past, we would have done it through a development agreement or an annexation agreement. But knowing that not every development comes through with a development agreement or an annexation agreement, we saw it fit to put directly into our land development code. So that's our second amendment.
Okay.
That is all I have to present.
I have a question on that one,
Yes.
please.
So you're putting a 2-year time limit on this last one,
Yes,
and you've indicated that at the 2-year mark, then something else gets triggered to where there's a discussion of some sort, whether there is a fine that is adjusted or something that's put into play.
Right.
What is the time frame after the 2 years, taken into a situation with Nirvana, to say it's an additional 12 months and then that is it, regardless of whether there is a fine or not? Is there that being considered, or is this basically saying after 2 years, it could go on for another 2 years given certain criteria? So,
so,
yes, please.
sorry, go ahead, finish.
No, that was it.
Okay. So, once the 2-year period gets over, the way our codes are being crafted or presented is to give the village manager the discretion to look at all of the circumstances as to why the initial 2-year period could not be met. And then, based on those conditions, determine whether an additional period of time, be it 6 months or a year, to grant to the applicant only if necessary. Because if the applicant has shown absolutely no, or the developer has shown absolutely no demonstration of any progress on the project, it doesn't make sense to simply give them additional time. But if they have gone through the project and are just about done and the 2-year period comes, or they say, you know what, there were certain events like COVID that happened that caused us an 8-month or a 1-year delay, then it would be reasonable to grant them additional time. So that would be based on the very specific circumstances and the context in which the developers are making their request.
Doesn't that leave it open for subjectivity as opposed to something that is objective, that says, here are the check boxes that have not been checked, period? Because what you've indicated is it could be 2 weeks, 3 months, 6 months,
Or a year.
12 months. That's a lot of subjectivity based on, because then someone else can come by, well, you gave it to so-and-so, how come I'm here? So is the process then, the way I see it, it should be one of checks and balances that says, here is what allows this to continue forward, whether it's financial, whether it's COVID, whether it's whatever, so that it takes away the subjectivity, which opens up another door, another Pandora's box, which I would say we prefer not to do.
So I understand what you're saying. So you're suggesting that we include criteria of which should be considered by the village. That kind of like narrows down our discretion. But I think these types of requests may come in many different shapes and forms, so to speak, with different circumstances under which these requests are being made. And we were looking to reserve the right to determine what that extension would be. And it could actually be more than 2 years for a project of great magnitude where they needed it.
Granted.
And so tying it down with specific criteria may hamper the ability to grant a certain amount of time that would be reasonable. But what I could say is we add the criteria, but also give the village an out, saying in
Exactly.
any other circumstance that the village may want to consider.
Everything is flexible. That's what I'm simply suggesting, that
Okay.
we state it as such, that there is a criteria that has to be met,
Yep.
but then still, there are specific circumstances that can come into play. What I mean is, what it does is, it doesn't leave us hanging in a position where someone could, if they wanted to, bring legal action based on subjectivity, based on any number of criteria that is either biased or otherwise. So I'm just trying to make it so that it is more objective. Then if there's a discussion, fine, let's say just go to the board, whatever it's gonna be, as opposed to putting this into the hands of Ray and saying, you made the call, I'm coming after you, and I'm coming after the village for whatever reason. And anything can happen going forward, we just don't know. So
Although-
that's what I would say. I would say, set the criteria and then leave it open for going
To give
forward.
you the example of the cannabis facility, we granted them the extension, but also said that that would be the only extension based on all of the circumstances under which the request was being made. They were also made to provide to the village a financial surety without having it written down in the codes. That was part of the agreement that they had to undertake following the term of their regular construction period or their special use period, and had to agree to it as part of this agreement following that, so.
And that's a great example.
Mhm.
But I do know, and I saw that the line in the sand was crossed off several times. So it was moved to end of May,
Right.
beginning of June, middle of June, beginning of July, whatever. It kept getting moved up because there was some type of criteria that was still set in. We never said, that's it.
We also have to look at it whether there is benefit to the village in allowing a project to continue. So like I said, it would be hard to hamper ourselves with that, only knowing that we are losing the bird in the hand, so to speak.
I understand. I understand. For me, it's all about
Yeah.
optics and expectations. And if that's it, and if we are a village that's gonna be easy to work with, we still have to have a criteria that says, this is the line, it's drawn, and that's it. No, I get the other circumstances,
Mhm.
but as long as it's in the discussion and we have those
Sure.
check marks, and that's what I'm
We
suggesting.
can certainly consider some of these criteria and also give us the availability to extend it at our discretion. Okay.
Go ahead.
No, I was just gonna say, I fully understand your position. I have to be honest, though, I guess I'm taking the opposite. I really don't think we should be that set definite guidelines or things like that. I think we should allow for the discretion. I think the village manager would be fine, and I don't see how, I can't imagine that two exact same projects with the exact same circumstances were to come before us, and we treat one way and the other another way, and then they take us to court or they're sue us because they said we weren't being fair or objective or whatever. I see that as very remote possibility. And I'm fine with the 2-year and then leaving the discretion up to the village manager in terms of extending. I mean, realistically, if they've done nothing for 2 years, they're not gonna do anything else, so we just say, too bad, bye-bye, and that's the end of it. But if they've already started work, are we realistically going to say, sorry, you have 6 months, get it done, and they're 90% done, and we say, too bad? What are we gonna do? I mean, at that point, we have to work with them, realistically.
But that's where we also leave the additional provision in there saying, and any other factor or circumstance as seen fit to allow for the extension.
Right.
Yeah, because my concern is, without the parsing ability of a Nostradamus, I don't know how you would establish what criteria we would want to include in here as a narrative, because you simply aren't going to be able to come up with every possible
Right.
scenario. So if you start listing them, then there's too many exceptions to those that you then can't include, because you didn't include that one as part of the criteria. Whereas if you leave it more open-ended as, in terms of the deadline with the review of the schedule, you allow for whatever circumstances might arise, given the discretionary purpose of the village manager. Because when it comes to projects and construction, there are just too many variables
Yeah.
that can happen that are going to, no matter how far-reaching we thought we were going to be to catch everything, we're not going to be able to in a narrative. So it's, you put the timeline together, the developer understands what that timeline is, and it then, the onus passes to them to tell us what that problem is.
Yeah.
We don't want to give them the opportunity to come back to us and say, but you didn't list that one.
Right,
There is also
exactly.
the added incentive, which we've provided here, that the village then has the ability to draw down on their letter of credit, which now is a financial burden to the developer. And so it is a very great incentive for them to complete the project within that 2-year period, because we can choose to either grant them an extension or draw down on their letter of credit too, so.
Let's say they ask for an extension, they ask for a 6-month extension, and the village manager says, no, I'm sorry, you have to finish the project in 2 months. Does the developer have the option to go to the village board or go some,
Yeah. The third paragraph provides the village board that
Okay.
option, yes.
okay. So they have,
They have
you know,
some.
if they feel like they're being treated unfairly
exactly.
or whatever, okay.
I have quite a few questions. This
Right.
one's near and dear to my heart, being a general contractor that works for developers. Couple things, I agree, there's no way, I mean, just in the last 4 years, the amount of different, obstacles that we've run into that have delayed us in some form or fashion, you never be able to drill down on anything specifically. Couple questions I have, Antonio said something about a village easy to work with. There's a few things of language in here that I feel kind of could open itself to allowing it to be a little bit more difficult to work with. Down in title, we're talking Title 10 here as well,
Yeah,
right?
yeah. Title 10 is what the language
Paragraph 2, where it says, village shall have the authority to order all work to be stopped at the recommendation of the village engineer or inspectors. I feel that's given a lot of power to an inspector, who has the ability to have the village engineer's ear anyway. I just feel like giving that power to an inspector is a little bit overreaching, in my opinion.
Actually, the clarification is that it is the recommendation of the village engineer to the village, so the 2 words before that. The village shall have the authority to order all work stopped, not the engineer, but we would
At
use
the
the
okay,
recommendation, yeah.
I got you.
The
So that's
recommendation.
not actually
It's
giving
not giving the
them-
village engineer or
okay.
the inspector
All
the
right.
power.
The
so
village
that's-
has the authority.
Giving them the
Yeah.
ability to recommend to the village.
Recommend to the
Yeah,
village to,
that, yes.
okay, all right, I get that.
Mhm.
That makes it easier. A couple other things. One of the things, the language says, 2 years after the approval of the plan. So that would be after like permit review and the plan is,
It's, the final
Officially-
plan approval is when the village board approves the final plan for these developments.
so I'm sorry, at that time, that's when the
Yes,
2
that's when the
year,
clock starts ticking, yes.
is there any reason it can't be from when the permit is issued?
That may be something to consider.
Just because I know there's,
That's-
for the job I'm on right now, we got approval,
Mhm.
say it was early October of '24. We couldn't start until end of November.
November,
So
yeah.
there was a long period that wasn't any burden on us,
Mm-hmm.
it wasn't due to anything that we did, that clock would have started ticking.
Mm-hmm.
And my project right now is a 26-month project, just for construction from when I go in there and take the cornfield away to when we're getting the final CO. So that was just
Well, that's
a
definitely
thought,
something to consider,
maybe.
yeah.
and then there was a couple other things in the red. It says construction shall be completed within 2 years of approval, which I just touched on. There was another portion, the developer shall cause all such work to be completed prior to the expiration of the 2-year improvement. Again, I'm sorry, I'm
That's the
being
third
redundant.
paragraph, yes, the beginning of the
Imply.
third paragraph.
Okay,
Or request an
We're
extension.
saying the
there
same
was-
thing 3 different ways, but
There-
with different conditions attached to each way that we
I
say
get
it.
that. There was one spot where it made me think that, the 2-year was either completion or commencement. Does this imply complete construction? Paragraph 1, let me go back. Under Title 10, developer shall within 2 years from the date of approval of the final plan or final plat of subdivision as described herein, construction and pay for the subdivision improvements required herein. My question was, does that imply complete construction? That construct and pay for
Yes,
subdivision
complete the
improvements? Okay.
construction, yes.
All right.
Okay, I can clarify
toward-
that. Mhm.
The last sentence in that one, subdivision improvements shall include but not be limited to public and private streets, utility, stormwater management, blah, blah, blah. One of the things that we've run into, say, construction is completing between November and March. Well, we can't do final landscaping until, a lot of times, the following June,
Correct.
when everybody's able to like finally go to the nurseries and actually dig up the plants. Is there something that can be, or is that included in a lot of these?
That's included in the red, which
Right.
says, unless a construction schedule is submitted by the developer and approved by the village outlining an alternate site or subdivision
Okay,
improvement, period.
so essentially, it's all about communication.
It's all
which-
about communication and
all right.
letting us know in advance, setting an expectation. That's kind of like making sure that both the developer and the village have come to an agreement that
Mhm.
based on the circumstances or even the magnitude of the project,
Right.
that there will be a certain amount of time needed to complete the project.
Gotcha, okay.
But good
Um,
questions.
But also with the agreement, the
Yeah.
annexation and improvement
Development
agreement,
agreement.
all of that can be done ahead of time if it's a
Right.
26-month
Yes.
project.
And
Right.
that is essentially where we have the flexibility ahead of time, that is, at the time of final plan approval itself, ensure that a timeline as well as all of the terms and conditions of the project be outlined and memorialized in an agreement that is agreed upon by both parties, the village and the developer.
Gotcha, that was my last question.
The only reason we're adding it to the codes is because there are the rare occasions where we don't have development agreements for certain types of project, and memorializing it in the code then covers all kinds of, construction projects.
Probably like Nirvana.
Correct.
Okay, all right, that was pretty much all I had.
No, I echo all of those comments, other
Mhm.
than they can be mitigated by clear communication
Yes.
from the developer to the
Mm.
village, right?
And that's one of the
But yeah, it's very common for us to have a huge delay between
Yes.
final village approval or city approval and when we actually have permits issued, right?
Correct.
And so 2 years would be very problematic, but not if this can all be mitigated by clear communication. from the
Communication is
developer.
key.
Right,
Yeah.
absolutely, and that's the red line
Yeah.
provision that I've added.
But yeah, I could echo also the comments about not being too restrictive here. I don't,
Yes.
I just do not think you can map out all of the criteria.
Can
We'd have
never
to
do
evaluate.
that.
Right.
Wait,
And the number of different delays we've had for factors way outside of our control, I mean, we keep getting new factors, every new development that we push forward. And so, yeah, I think having the wherewithal to make those judgment calls is good, within reason, but nope, nothing new on my end.
Our goal is essentially to strike a balance between being developer-friendly as well as addressing the needs of the community, not to have their lives disrupted during the construction project.
But I
Great
agree, I
comments.
think Scott's comment about the permit being a considering, in terms of that timeline.
Yes, that I'll make a note of, yes.
Becomes an
Mhm.
important. Okay, all right, Lon?
Yeah, so I have just one left over. Everything else was covered. So on Title IX, where it says failure to commence construction, and then it says will automatically render void the final plan. So do we have somewhere where we define what does that mean to commence construction? Because they can come up and put a construction fence and say we will start construction, and that can stay for 2 years. So is there like something that we need to know, like, are they actually progressing? Is there something that we know how they would?
So that portion that you read from is the existing provision in our
Okay.
code right now. The red line is the additional paragraph we're adding to our zoning code section. And then under Title 10, everything you see under Title 10 is new. I should
Okay.
have actually made that whole paragraph,
Okay.
section red. But commencing construction essentially means obtaining a permit for, say, tree removal, for mass grading, for utility installation, for demolition of an existing building. All of those can be classified as commencing construction. It doesn't necessarily mean commencing the new construction as proposed by the final plan, but also prepping the property for the new construction to come in. So,
Okay.
again, we have not defined it, commencing construction, but perhaps we could look at seeing if there's something a little more specific that at least gives guidance to a developer and the village to bank on something, so to speak, that, well, this is what the code says, so if you haven't done it, you haven't started.
Right.
could it say something like commencement and continuance of construction, something like that, so
Yeah.
that they're not just plopping down some iron on the,
Yes,
Job site.
yeah, actually
we're-
staging is
we're
not commencing
mobilized, yeah.
construction, correct,
I mean,
yes, you're right,
there's all
absolutely.
sorts of tricks.
Yep,
Mobilized, now I can build a job 90% done.
Right.
I'm mobilized.
I'm mobilized.
I'm
yeah.
mobilized, yes. I
If-
brought
if
my
there's
truck.
Not that
demo-
that's ever happened.
If there's demo on the job, it's all getting paid there.
Not that I ever did that.
No, these are very good comments, thank you, this is
Well-
great feedback.
If this was to be tied to permits, I don't think it's a bad idea, but
Mhm.
I think including some additional language that those permits need to be sought in, reasonable timeframe.
That is correct,
Yeah,
that is
yeah.
the other thing, they could wait 5 years to come in and get
Well,
their
exactly.
permit.
And so, yeah, I think there is, going in that direction wouldn't be a bad thing, but
Yeah.
some additional language would need to be included.
Mhm. Yeah,
An excellent point.
Yeah, even if it's like a 90-day from approval to permit or something like that.
Right.
Which
Because
is-
commence construction is the 2-year period in the existing provisions of the code. But obtaining of permits to get going within 2 years, because they don't want to say, okay, in the 11th month of the first, or the end of the second year, I've come and gotten my application in, and now it'll take me 6 months more to get my permits because
Just
of
keep kicking the can.
kicking
Yeah.
Right,
down the
right.
road.
Yeah.
Okay, no, that's also very good feedback, yes.
Personally, I think 90 days from approval of plan to
Mhm.
permit issuance is
Reasonable?
reasonable.
No, extremely, yeah.
Yeah, I don't think any more than that would be a little bit
Right,
too forgiving.
yep. But by that time, we should also get a pretty good indication as to whether a developer is intending to proceed or not, to,
Okay.
3 months.
Antonio, anything else to add?
No.
Questions?
Appreciate the feedback, thank you.
Okay.
So will this come back to us, or are you just
I
gonna?
will take your feedback and include it in there. Do you want it to come back to you? or
No.
unnecessary? Okay. I just want to make
I mean,
sure.
this was enough fun.
Yeah.
Let's move on to
We
something
typically
else,
take your feedback and
just
quickly
as
incorporate-
exciting.
In fact, what we will do is we'll incorporate it as your findings to our staff report.
All right,
We'll
thank you.
include it. I've made notes.
Okay. Then are we ready to move to deliberation, commissioners?
I thought we just did that.
Then I would entertain a motion to close the public hearing on application PZC 2025-08 and move to deliberation.
So moved.
Second.
Call the roll, please, Colleen.
Commissioner Castillo,
Aye.
Commissioner Gloaz,
Aye.
Commissioner Kovacevic,
Aye.
Commissioner Morrison,
Aye.
Commissioner Schultz.
Aye.
Chairman Stratman.
Aye. Any further deliberation?
Nope.
No? Okay. Then I would entertain a motion on application PZC 2025-08 to receive into the public record the staff review of compliance of this application with the zoning standards as presented by staff, and to receive the testimony presented by the members of the PZC, and to make these standards and testimony a part of the official record for the application and findings of the PZC, and to recommend the village board approve the application for amendments to the text of the municipal code to clarify the land use status of municipal structures and uses within the zoning code, and to establish time limitations on developments.
So moved.
Second.
Did I hear that you added with the revisions that were?
Yeah, that was part of the testimony of the commissioners.
We'll add them as
Yeah.
part of your findings. Thank you.
Okay? Call roll,
Commissioner,
please.
Commissioner Castillo,
Aye.
Commissioner Gloaz,
Aye.
Commissioner Kovacevic,
Aye.
Commissioner Morrison,
Aye.
Commissioner Schultz,
Aye.
Chairman Stratman.
Aye. So, recommendation is given, and this will appear to be to the village board when?
Most likely the first meeting in July, so that we
Okay.
can get going with it.
Good.
Thank you.
Thanks, Sarosh. Okay, do we have a staff report on upcoming projects?
Yes, we do. So we now are getting ready to receive a couple of significant projects that will ultimately be brought to you either in July, August, or September.
Okay,
Those projects include the redevelopment of Block A, which is in the works, ready to be submitted. The annexation and development of the northwest corner of Miller Road and Rand Road with the Advocate Health Clinic project. And then another annexation down the road for the garage condo project outside of our bounds, but just across Windstone at what we refer to the Calabrese property. It's a 20-acre property. We also then further down the road will be looking at the Regal property redevelopment with apartments. All of these projects are already familiar to our village board because they've come through for courtesy review, and they've come through at various times for courtesy review. And so now these are materializing into actual formal applications that will be brought to us, and then we will present to you at public hearings.
Now, the Advocate property will require annexation as
Annexation.
well as part of the
Yes.
project review itself, correct?
Yes,
So it'll be a
and so will the
two-part.
garage condo project as well, yes. So we'll be looking, for both those projects, we'll be looking at, first of all, annexing the property, zoning it within the appropriate zoning district that, the land use best fits, and any, modifications to the code through the plan development, plan unit development process. So all of those will be put together and presented to you, so.
Okay. Now, is Block A going to be a PUD as well?
Yes, it will have to be a PUD.
All right. Well, we've got some exciting stuff coming up.
Yes, exactly. It's gonna be a busy late summer and early fall.
Antonio, do you have your $5 million car that you want to put into the condo?
Yeah,
Okay. Soroush, thank you for
that
the
is all I
update.
got, yeah.
Okay, there's no one here to want to offer anything from the public, so,
We haven't submitted yet. Okay, we have one application being prepared for submittal, but we don't know if it's coming to you in July or not.
oh, okay.
And that is for the Salvation Army to occupy or rent, retail tenant space in one of our shopping centers.
All right,
But
good,
not confirmed yet.
okay. All right, anything else, commissioners? Okay, I'd entertain a motion to adjourn.
So moved.
Before I forget, sorry, I
Second.
failed to introduce Mr. David Majeski, our building services supervisor. I know he's been to one of the meetings before, but just in case you weren't at that meeting, Dave has been with us since February of this year as our building services supervisor. He took the position that Mary Meyer used to hold after she retired.
Right, and so, Antonio, we'll start with you. The spelling of his last name.
Rose, can you repeat that, please?
I know the spelling of his last name.
D-A-V-E.
There you go, you got it.
There you go, very good.
All right. So, did we do the motion to adjourn?
Yes, we did.
Did we call the roll?
No.
Okay.
Commissioner Castillo,
Aye.
Commissioner Glowaz,
Aye.
Commissioner Kovacevic,
Aye.
Commissioner Morrison,
Aye.
Commissioner Schultz,
Aye.
Chairman Stratman.
Aye. We are adjourned. Thank you,
very
everyone.
much.
Thanks, Soroush. Thanks, David.
Soroush, I have a question.